أعوذ بالله من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم السلام عليكم ورحمة الله وبركاته. This is a brief presentation about wasiyah or will from an Islamic perspective. And after my presentation, Naushad Bhai will present his from the law of the land, I guess. English version, English law. Okay. So, I'll be quick. I won't be very long. Okay. Now, if you see Quran Majid first, Quran says, it is prescribed upon you when death approaches any one of you, if he leaves behind wealth, then he should make a will, wasiyah, for his parents and near relatives in a fair manner. In the 1/3, this is a duty upon the pious people. This is Quran Majid, chapter 2, verse number 180. There are some verses of Quran like in Surah Nisa and in Surah Maida. Interestingly, in Surah Nisa is chapter 4, verse number 11 and 12. In that particular verses, you'll find Allah subhanahu wa ta'ala has shown you how to distribute and who are the shareholders. But we won't go to that because we don't have enough time. Now, what is a will? This is from the Islamic laws of Agha Sistani. He says that a will is supposed to direct that after one's death, a certain task be completed, or that a portion of his property be given in ownership to someone, or that the ownership of his property be transferred to someone, or that it be spent for charitable purposes, or that he appoints someone as guardian of his children and dependents. A person who is to give effect to a will is called executor or a wasi. Sometimes you write a will, yeah, but then you seal it, you sign it, then you inform an executor, which is called also a wasi, who is going to carry out all the duties after your death. You trust him. It can be any person. He can be any person whom you trust. You know that he's a trustworthy person. That is called a wasi or an executor. Now, question. Why are we discussing an Islamic will? Why should we be discussing Islamic will? Excuse me, I'm not very confident. I'm not very comfortable in sitting, so if I stand. Okay. If you go to think about Islamic will, you will find that in countries like India, other secular countries, when you have got a problem in family, especially when an elderly person dies, a father dies, and if there's a dispute, if they go to a court, then the judge will sort out his problems and will solve his problems based on the denomination and on the faith of that person who has come. They won't solve the problem based on their law. But here in the West, if you don't have a will, then Naushad Bhai will explain you what will happen. So that is why it is good for us that we write will according to ourselves. And when we say ourselves, we are Muslims, we will write according to Islamic Sharia. And there's no need to say that this is Islamic Sharia. This is according to how I want my estate to be distributed. And then you will divide it based on Islamic Sharia. Now, you might tell me that, no, I don't mind. Let the estate distributed based on English law. Then what will be the consequence? Now, from your family, if the shareholders or your potential heirs, if they end up getting more or less, then if they get more, it is ghasbi. They have to get what Islam says. Now, firstly, if a person dies without a will, the government appoints an executor who will divide the estate among the heirs as he or she seems fit. The pay of the executor for this job will come out of your estate, and the government system takes its time in getting jobs done. 1. 2, from the Sharia point of view, your heirs may get more or less than the shares specified for them in Islam. Yeah? By not writing a will, you are leaving the door open for a non-Islamic authority to distribute your estate according to its own views. So this is a very important point to keep in mind. That is why we are writing a will. Now, question. Is it wajib to write a will? Is it must? Wajib means obligatory. Is it must? The way we pray, the way we'll fast in Mahr Ramadan. So is it must for me to write a will? Is it wajib? I was just looking at a hadith. There are so many ahadith. To that extent, Imam Ali alayhi salam says that if a person does not write a will, he is disobedient to his Lord. And you have heard several ahadith that Rasulullah says a person should not sleep without a will underneath his pillow. He should keep a will. So, no, it is not wajib, definitely. Yeah, because to make the rules and to bring the rules is the work of a jurist. The jurists have not said it's wajib. Yeah, but if you remember the verse which we said initially, here is kutiba alaykum idha hadara ahadukumul maut. Kutiba. What tells you that? Kutiba. Prescribe. Yeah, or this is 1. 2, it is said that it is prescribed. Here kutiba means, thank you. Here it means that ya ayyuhalladhina amanu kutiba alaykumus siyam kama kutiba alal ladhina min qablikum la'allakum tattaqun. So when the word kutiba comes, it is prescribed upon you fasting. So when it comes to fasting, it is wajib. When it comes to will, the Marajas have not said it is wajib, but it is highly recommended. It is mustahabbe muakkida, like marriage. Marriage, it is said that an-nikahu min sunnati, faman raghiba an sunnati falaysa minni. Whoever does not marry, he is not from me. Can you imagine? So it's highly recommended. The way marriage is, it's not wajib marriage, but it is highly recommended. And so is writing of the will. It is highly recommended. Now, this is done. This is done. Okay. Although the Islamic law does not say that making of the will is a must, but by looking at the consequences of not having a will, it is necessary from the Sharia aspects. Now, how much control do we have on our estate after we pass away? Because I've got estate, my own, I'm about to die. It's not necessarily that when I'm to die, then I write the will. No. Yeah. Any person who is a mu'min, who is a believer, must write his will. Okay, now how much control do I have? Because if I want to follow Islamic law, then Islamic law says that you have got 1/3. That is absolute control, absolute power from your will, 1/3. 2/3, it is up to Sharia. According to Islamic laws, Islamic law will tell you who will inherit from you, 2/3. 1/3, it's entirely up to you, whom you want to give. Now, there are 3 possibilities. One possibility is he has full control over it through a will. Second possibility, he has partial control over it through a will. Third, he has absolutely no control over it. Islam goes with the second option. He has partial control over it through his will. That is 1/3. You've got partial control. Islam has taken the middle position. It says that when a person dies, he still retains the right to decide about up to 1/3 of his entire estate. But as far as the 2/3 is concerned, the deceased person loses the right to dispose according to his wish. So you have got absolute control there, and 2/3 must be distributed according to Sharia. Now, if you die and you have not written anything, then you have lost that absolute control. You have lost that power. Sometimes you know that sometimes you've got a son and a daughter. And a son, perhaps he's professional, he's earning, he's got everything. Yeah, he's well-to-do financially. He can support himself. But a daughter, she's in a problem. So that 1/3 you can allocate to her. You have got right. Because now people might tell you, Islam gives more to the son than the daughter. Just double. Yeah? But then if you work out with the numbers, they can get even same. If you give 1/3 to your daughter. Not necessarily a daughter, but you can give to any organization, your friend, even to a non-Muslim. That 1/3. Yeah. You can give to a non-Muslim, to another organization. It's entirely up to you. And the executor should implement what you have said. No. If you don't want to, yeah. Okay, so the 1/3 is absolute control. I don't want to take much of your time, Rashad Bhai, because you have to also give much. I know it's important also from English version, so I'll be quick. Yeah, but it's a very interesting topic, I must say. So this is one thing which I must mention. The 1/3 is wasiyah, and the 2/3 is mirath. You get what I mean? Absolute control is wasiyah. You know, we say wasiyat kar, right wasiyah. That is 1/3. This, it will go to the potential heirs, whether you like it or not. Important is that. And even in fiqh, there are 2 chapters. It is Kitabul Wasiyah and Babul Mirath. And it doesn't follow each other. First it comes Kitabul Wasiyah. After other chapters, it comes Kitabul Mirath. So Mirath is 2/3. Wasiyah is 1/3. This is very important. Because it is upon the father or the person himself to judge and to think whose right is for me to give. Who deserves more? Perhaps my wife, example, I know she will suffer after my death. So that 1/3 I need to give to her. If I don't write anything, then you have lost that absolute power and control over your wasiyah. Okay, so mirath is inheritance. And wasiyah is will. This is the exact meaning in English thesaurus. Wasiyah is will, mirath is inheritance. Now, the 2/3 must be divided according to the shares specified by the Sharia. Most of these shares have been specified in the Quran itself, in Surah Nisa, chapter 4, verse number 11 and 12, for those who want the reference. Now, this right of disposing the 1/3 according to your own wish can be exercised only by making a will. You can do whatever you like with the 1/3. Give it to a family member, a relative, a friend, a charitable cause, or organization, etc. when you are alive. The time you are dead, you can't do anything. For example, you can use the 1/3 of a part or a part of it to make, if you like, the shares of your wife or your daughter equal to those of your other children. Because the wife ends up getting very less. If you see in that, in the 2/3. Yeah, she gets very less, isn't it? So you can help, you can work out your numbers in such a way that she gets also equal to the son. It should be written. It will be given after your death, but it will, in your wasiyah, you will write it, isn't it? It will be distributed after your death. But if you have not written, then the question which was raised here, Naushad Bhai asked that, what if you don't write anything? You don't say anything? Then yes, it won't be exercised. It will be exercised and it will be implemented definitely after your death, but it should be written. If it's not written, it won't happen. Nobody can say on your behalf after your death that you should give to that daughter or to your wife. If yourself you have written, then yes. 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 Yeah, then he will, then there is English version, he will come to it later on. Yes. Yeah. Then it will be distributed, isn't it? You don't have any control. It will go to the estate. Then it is up to the heirs now to appoint any executor, any wasi, or themselves, and they will start distributing it. Then the whole thing will be divided. First, the marhum himself, he had a power on that 1/3. Now he won't be having power. Now it will be divided, the heirs, potential heirs. And we'll come to the category of the potential heirs soon. Now, a daughter normally gets half of a son's share. What if the daughter is more in need? You can always use the 1/3 option to allocate more to your daughter. This we mentioned. Now, what is an estate? An estate is the collective name for everything that you own at the time of your death. Before distributing the estate among the heirs, the executor of the will has to pay off all the debts. So here when a person passes away, they say that if their debts approach the son of marhum, so sometimes you don't know their debts. So you have to deduct the debts. Okay? Legal as well as religious. So you've got legal debts, religious debts. Okay? Unpaid khums, zakat, kafara, wajib, hajj, whatever. Even the wajib portion of the funeral expenses comes out of the estate before it is distributed among the heirs. Then the executor has to comply with the instructions of the deceased about the 1/3. For example, to make appropriate arrangements if the deceased has specified the amount for hiring a person for doing his missed prayers and fastings, etc. After that, it will be divided amongst the heirs, the sons and the daughters. Then we'll come to the categories quickly. Now, these are the circle of heirs. We have got only 3 categories of the heirs. But do know, spouse is present in all the categories. Spouse will be there, even if they didn't have a relation. The time nikah was recited, the time it was said ankahtu, and the man said qabiltu, even the next day a man dies, that woman will have right on the will, on the wasiyah. Her haq will be there. Now, so spouse is there. The first category is parents and children. This is the first category. First category. Okay, if parents are dead, then the children and the spouse. So spouse is there in all 3 categories. Her hisab is different completely. So the first category is this. Now, the second category is grandparents and siblings and their children. But now one thing must keep in mind, that even one heir is present in first category, it won't go to the second category. Say a marhum didn't have parents. Most of the parents pass away earlier. The child survive longer. So if the parents died, but the children are there, but if a person had only one son, if only one son is there, it won't go to the second category. It won't go to the siblings and their children, even if one son is there. And even in the second category, if in first category there's no one, in second category there is one person, then it won't go to the third category. So first category is parents, children. Second category is grandparents, siblings, and their children. Third category is paternal uncles and aunts and their children, maternal uncles and aunts and their children. So here you've got parents, then you've got grandparents, dada, dadi, nana, nani, and you have got siblings. Then you have got paternal uncle is kaka, chacha, and fui or pupi, whatever. And then here you have got khala and mamu. This is the third category. Yeah? And if you are more interested to know more, you can go to Tawzi of Ayatollah Sistani, and he has explained in depth about the categories. But we just made it easy for you to understand. Yes. Yeah. Yeah, yeah, yeah. Paul. He becomes a lucky guy. 2/3, yeah. Yeah. If he is not there, then it goes to the other ones. Yeah. Hmm. Yes. 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 Even the mother's estate will be divided like this. Exactly. This is applicable in both, not only for a man, or even for a female, yes. Because sometimes if your mother is richer, yeah, she has got estate, she is a businesswoman, she has left, behind wealth. So yes, it will be divided in this way. Yes, and then husband, yes, definitely. Yes. So, now, even a single person from the inner circle will exclude those who are outside. Even a single person. Even a single person from the smaller square will exclude those who are outside. The surviving spouse can never be excluded by any blood relative. There you go. So this was based on Sharia perspective. Now, it's up to you, Naushad Bhai, to explain us a will based on English law.
Can I ask you a question? So if husband and wife have divorced, what is the divorced spouse's right in Sharia?
Okay. If they are divorced, then there is no right. No right. Unless, now sometimes, people might say that a wife, example, she says that I want my right to be preserved. Yeah. So what she can do is, the man can, or sometimes she thinks that because her right is very less compared to others, because in the 2/3, you have got parents, and the parents are alive. You have got children. So you have got another way, yeah, and that way, and it's allowed to say that I will, and I've got this house example. I will do hiba. Hiba means I'll gift it to you. I've given it to you. This is your right. The husband can give this to the wife. But then again, question comes that what if after he has already given it to her, and after that, they split, and divorce takes place. Then if you have given without a condition, yeah, without mashruta, hibal mashruta, there's a problem. So you can give her with a condition, provided you don't leave me. If you leave me, then this is not your right. So there should be a conditional clause there. Or sometimes you'll find you've got parents saying that I've got 3 kids. My one son is not obedient, and I don't want to give it to him. Yeah? So the remaining I want to give to others. So then you can either, in that 1/3, you give more to other siblings so that his share becomes less. Yeah? This is one way. You can say that I give him less, example. Yeah. Or you can gift it while you are alive, then the concept of inheritance won't remain. Will won't remain, because I have given all my estate while I was alive. lifetime. I was alive, I gave to my 2 siblings. But you cannot say that when you are dead, you cannot say that this son of mine should not inherit me. Only 2 people will not inherit. If a son becomes a kafir, or if a son kills his parents, and if a judgment is passed that he killed his parents, then that child won't inherit his parents' estate. So you can, okay, see, it's not good first. A person needs to have a big heart to forgive children. Yeah? But I'm just saying, just in case, for some reason, a parent says, I don't want to give to my son. God forbid, if a parent says like this, then if he wants Islamically, then he should either gift in his lifetime to his other 2 siblings, whatever, or in 1/3 of his, he should give to other siblings so that the share of that son becomes less. It's not applicable. Because when you die, already when you die, then your estate will be divided based on Sharia, the 2/3. Yes. His right is having there. He's having his right there. Or you say in your will, example, that I've given him gift to these 2 examples, so that you play now in your own way. The way there are some ways to play with 1/3 in wasiyah. Yeah, so that my daughter gets more, example. You can do that. Sharia has given that flexibility. But if you have not said anything, then that will be applicable. Yes. No. Definitely before his death. No. Okay. About meher, if you see in the fiqh books, they've said that meher is a marriage gift. Meher is a dowry, is a marriage gift. A dowry. She can, yes, if she wishes. If she wishes. But now, many a times when I go to recite nikah, I tell them, because many people don't have a concept of meher. So I tell them it's entirely up to the bride what she wants to demand. What she wants to demand. She wants to demand a diamond ring. She wants to get a rose. She wants to get a Hajj ticket. It's entirely up to her. Now here again, she can use, maybe, she can say that, where I understand in Iran and in Pakistan and other places, they demand a lot. It has got its own disadvantage. Then it discourages men to marry also, because some are not, most of them are not well-to-do, they can't afford. Then women demand a lot of meher. That's, yes. No. We have misunderstood. Perhaps we have got that attitude, while you see other places, a lot of amount is demanded by the bride while recitation of nikah. That is wrong. I shouldn't say it's wrong. If it's an agreement, if the husband agrees, that's fine. Yes, it has happened. Yeah. Yes. 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 In Dar es Salaam, before they recite nikah, they have got conditions written on a paper. Okay? So the groom is given that, and he reads, you see. So I've not gone through that, but perhaps one of the condition I've heard in other places, not in Dar es Salaam, in other places, they keep condition like when, God forbid, if we want to split, then you don't trouble me in giving me consent of talaq. Sometimes because a man has got that power, so then he troubles the wife. And if they want to split, he's not staying with her, yeah, but yet he troubles. Yeah, he doesn't provide her financial assistance, nothing. Yet he doesn't give a consent, then the woman gets, So they're splitted, and he doesn't free her. So things like that, the way Jabir Bhai says, yeah, they keep conditions. Such conditions are being kept, and it's fine during recitation of nikah. Okay. Yeah. Yeah. And yeah, perhaps it's a gift. Gift. Okay. It's interesting. It's interesting. It's interesting. Meher, yes, it is like when a wife demands, it is settled already. But when she demands, then you give her. If she doesn't demand, you don't give. Yeah, but if she didn't demand, then it's fine. Yes, yes. But then what she does, but but sometimes you know that your wife, out of love, she did not ask. It's fine, it's fine. Yeah. Out of love, I have not given my wife till today her meher. She didn't ask me also. Okay, then again it comes to the elder son, isn't it? Because the way we say that a mother, even if she feeds her child, her infant, she can charge the husband. But she doesn't charge, does she? She never charges. So these all are, and it has never happened that. Yeah, because it becomes a family then. That bond is there. Yeah, then she's given. Yes, then again it will come out from 1/3. You remember 1/3 we said? That in 1/3, all the debts, just in case, if the wife demanded, then it will be deducted from 1/3. All the debts will go from 1/3. All the religious, 1/3. Even this kafan and karimani and everything should come out from 1/3. Everything. We mentioned this in that slide, if you remember. Up to 1/3. So, uh-huh. Mm-hmm. No, from 1/3. He doesn't have right from 2/3. Yes. So first, yeah. Yes. Yeah. Yes. Yes. Yes, yes, yes. 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 Bismillah.
Can I have my slide on, please, if that's okay? Assalamu alaikum, ladies and gentlemen. Thank you very much for giving up your lovely evening and coming here to listen to this very riveting presentation on wills. This is the English part of the presentation. I won't be very long. I will just follow the slides as I've got up here. If you've got any questions, please jump in and ask any questions you want to, and I'll do my best to answer. In the first instance, if you don't leave a will, then according to English law, the intestacy rules will apply, and the intestacy rules will mean that your estate is going to be distributed according to the intestacy rules. The intestacy rules are quite rigid, they're very prescriptive, and it is difficult for somebody who's not made a will and his intention was to distribute according to the Sharia rules, and the person who then inherits is not willing to distribute the estate according to the Sharia rules, it becomes quite difficult. First of all, the intestacy rules, all the personal property and belongings of the person who has died are going to be distributed according to the intestacy rules. The first 250,000 of the estate will go to the spouse. So if a man dies, assuming the man has died first, leaves a wife and children, then the intestacy rules provide that the first £250,000 of the estate will go to the wife or to the spouse. The remaining will go to the spouse. Half of it will go to the spouse and half will be shared by the children if there are any children. If there are no children, then the wife will inherit everything or the husband will inherit everything. The example there is Muhammad Ali is married to Zainab and they have a daughter called Sarah. Muhammad Ali died without leaving a will. His estate is worth 450,000. After Zainab inherits her share of 250,000, the estate that is left is worth £200,000. Zainab can have half of this, which is going to be £100,000, and the rest will go to his daughter. That's right, yes. The wife or the spouse will inherit the whole bulk of the estate. English legal law is based on the Wills Act of 1837, and there must be compliance with the Wills Act in order to have a valid will. Insofar as compliance is concerned, there are some procedures that are laid down by the Wills Act of 1837 and then the rules. Basically, in order to make a will, you have to be a mentally sound person, you have to be compos mentis, and over 18 years of age. Any format is acceptable as long as it is in writing. The will must be signed and dated in the presence of two independent witnesses. Really, those are the basic requirements of a valid English will. In terms of inheritance, you can leave your assets or estate to whoever you want to. If you contrast that with the Sharia position as Maulana set out, you will know that the Islamic position is very prescribed. You've got your prescriptive rules, whereas in insofar as English law is concerned, you can leave your assets to whoever you want to. This rule is subject to if you have any dependents or if you have a wife and they've been excluded from the will, then an application can be made to a court under this statute, which is called Inheritance Provision for Family and Dependents Act 1975. Principally, the two dependents may be wife. Any dependents it could be a child or adult, and they must show that they were dependent upon the deceased in order to make a claim under that statute. There is an interaction between property law and the will's inheritance position. Just to explain, most people tend to own properties and they invariably own the property in joint names. Sorry. Couples may jointly own their home. There are two different ways of jointly owning a home. These are beneficial joint tenancies and tenancies in common. If the partners were beneficial joint tenants at the time of the death, when the first partner dies, the surviving partner will automatically inherit the other partner's share of the property. However, if the partners are tenants in common, the surviving partner does not automatically inherit the other person's share. Same with other jointly owned assets, bank accounts, shares, etc. You might ask why I've put this up on the slide. The reason why I've done it is that you need to appreciate that in English law, if you have assets that you own jointly as joint tenants, then automatically on your death, the principle of survivorship will apply, and what will happen is the survivor will automatically get those assets, and your will not operate to divide those assets according to your will. It'll automatically go to the survivor. So if you want to comply with the Sharia position, then if you want your 50% share of the property to be divided according to Sharia rules, you must sever the joint tenancy and turn it into what's called tenancy in common. And if you turn or convert your property into tenancy in common, you will be able to then leave your 50% through your will to whoever you want it left to. This is a bit of a difficult concept to actually grasp in the first instance. Are you guys with me, or are there any questions that you want to ask? Yes. 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 You're talking about inheritance tax. That's a different issue. But in terms of the account or the asset that's owned jointly, survivorship will apply, and so on your death, it will automatically go to the survivor. For inheritance tax purposes, even though your 50% is going to go to your survivor automatically, under the Inheritance Tax Act, your 50% is counted up as part of your estate for tax purposes. Yes, that's a bit difficult to get your head round it, but the Chancellor of the Exchequer wants his slice of the money no matter what. They are property concepts or concepts in property law. In the olden times, when it was not possible for somebody to leave a property to somebody else, for example. So say you've got A and B jointly owned property, and A wants to leave the property to C, it wouldn't have been possible for A to leave his share to C unless he actually did something in holding that property in a different way. And it was the courts that devised the equitable principle rules of holding the property as tenancy in common. So you can actually convert your joint ownership and hold it as tenants in common. What happens is, if your property is registered at Land Registry, you can fill in a form, you can apply to the Land Registry to have your property, you still hold it as joint owners, it's just converted into a tenancy in common situation, and on the Land Registry document, the office copy entry, it'll show that there is a restriction entered on the property. In other words, one person can't sell the property without the other agreeing, or if there's death, then of course there has to be another trustee appointed, so two people would have to sell in order for the divisions to be to be divided. You can do it now. If you wanted to do it, yes, but you must do it before death, because it's not possible to do it after death. Yes, you can do that. You can transfer all your property in your will to trustees. So you can appoint two trustees, and you can transfer your property upon trust to them, and you can then prescribe the various divisions between your relatives. So you can say, my wife will receive 1/8, my son will receive 1/5, my daughter will receive whatever the prescribed amounts are that they will receive. So you can then divide up your assets. There are two ways of doing it. One is you can either do it in the will and set out the divisions or the prescribed amounts in the will, or you can leave it all to your trustees and you can have a letter of wishes done. And in the letter of wishes, you can write up that you want the Sharia divisions to be carried out by the executor or the trustee that you've appointed. So it is possible to do that. Just moving on then, if there's no one to inherit, if there are no surviving relatives, under the intestacy rules, the whole of your estate will pass to the Crown. So the Treasury solicitor will get involved, and he will register his stake in your property. That's not a good thing to do. So clearly one reason for writing a will and not letting the state having hold of your estate. You can always write a will, and you can donate your estate to the charity, but you must say that you want to give it to the charity. It's not an automatic thing. Make a will. Why? As Prophet Muhammad, peace be upon him, said, not proper for a Muslim to pass 2 nights except to have his will testament near his pillow. Sharia, highly recommended. I think Maulana covered this aspect of it, and correct me if I'm wrong, but it's not wajib but mustahab to make a will. Highly recommended. Thank you. So again, you can control the ultimate destination of your estate. Not satisfactory to rely on intestacy rules, and also it can be good inheritance tax planning, which is your point. just to mention, and you may already know this, that currently you are allowed to have £325,000 as a lifetime allowance. If you leave an estate behind which is either 325,000 or less, then no inheritance tax is payable. If your estate is more than £325,000, then any excess above that, you pay 40% tax. If you leave 10% of your entire estate to charity, then that 40% is reduced to 36%. Any questions on that? There are some changes that were made in the last budget. The allowance is going to increase incrementally, and I think it's 2020 that it'll go up to 1 million. So if your house is worth, yeah, it's only in relation to your house that you live in, not your entire estate. So, and this was to make provision for a lot of houses in London because they've increased in value, and a lot of people end up paying inheritance tax. So I think it's allowing the increase in value and bringing the inheritance tax provisions in line with the increase in value. No. It's going to be universal up and down England and Wales. There's no tax payable from if the entire estate is inherited by a spouse. There is no tax payable on the death of the first. Tax is payable on the death of the second. But if the 325,000 has not been used, then on the death of the second, the allowance will be doubled up to 650,000. So it can be used on the death of the second person. Making a will suggests you use a professional person, although homemade wills, you can make them, but they're not really recommended because, what does that mean? Yes. Yes. If you've made a will and you've used a homemade will and it complies with procedure, then that's fine. Yes. Yes, it must be witnessed by two people, two independent witnesses at the time, and the witnesses must be present when you sign the will. All the wills need to be witnessed. If it's not witnessed, it will not be a valid will. It will not be admitted to probate. G. Yes. Yes. As far as I understand, the inheritance rules are going to apply to the property, the family home, so that if there is an increase in value in the family home, because sometimes inheritance tax has to be payable on death, and you lose the family home because you have to pay tax. And in order to preserve the family home and protect it from the tax position, those rules were brought in, so it'll just be the family home. Okay. Making a will. Suggest you use professional person. Homemade wills are not recommended, as far as that's my personal opinion. Again, if you make a will, you can appoint your own executors, people you trust who will carry out the administration of your estate. This is very important. As far as I know, according to Sharia, you can appoint as many trustees or as many executors as you want, but they must be Muslim first of all, and they must be sane. They must be of sound mind. It's important that if you want executors to carry out your wishes according to your wishes, and they may be Sharia wishes, then trusted people are more likely to carry out your wishes than not. Again, if you make a will, then you can direct how and to whom you want your estate to go to. Executor's job, in terms of executors, as far as English law is concerned, you can appoint as many executors as you want to, but it's recommended you appoint at least 2. Executor's job really is to, I often get asked about this, that what do executors do? It's usually only after death that they have to administer your estate. That's basically it. What does that involve? Executor's job is to collect and value the assets. Once they've done that, they apply for what's called grant of probate to the probate registry. Paperwork forms are required. They need to be completed. Once the grant of probate has been received, that's a court stamped document which gives the executor the ability, the legal authority to distribute and deal with the estate. Moving on to the next slide, which is interaction between English law and Sharia. No, it's fine. I'm not quite sure what the Sharia position is, where yes. 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 According to the intestacy rules, yes. Yes. Okay. Just to perhaps add some clarity on that point that you raised. If you make a will and you want your executors to charge for their time for the administration, then you can do that. You have to put in a clause in your will. If there's no will, then it's the Treasury solicitor who will charge for his time, and he will take that out from the estate. Okay, just going on with the particular points. In terms of English law, you can leave your assets to whoever you want to. In the Sharia, prescribed by Sharia rules, many difficult issues arise in terms of English law. First of all, English law doesn't recognize Sharia-made wills. You have to be compliant with English law. Also, the position relating to if the house is owned by 2 people jointly, and you wanted, or your intention was to distribute according to Sharia position, then the difficulty would be that the survivorship principle would actually mean that the property would go to the surviving partner, and it may not be that your wishes would then be carried out according to Sharia. Sharia rules I've put on there onerous, so Sharia rules can be onerous and not easy, because it may not be easy to split the assets according to the Sharia rules. If you've made a will and you've left assets according to the Sharia principles, so say for example the wife gets an eighth, the parents, if they're alive, they get 16.66%. The son gets whatever, or the daughter gets whatever's remainder out of it. If there is a house and the wife actually lives in the house or the husband lives in the house, and your intention was to divide the property according to the Sharia principles, then all the assets would need to be sold, and it may be that the wife will probably, or the husband will not have a house to live in. And that becomes a difficult issue as far as English law is concerned and Sharia wills are concerned. And that's why I say that assets may need to be sold to administer the bequest according to Sharia. One interesting thing that I have come across over the past years is the question of a waiver. Now, this is where, if, for example, the wife is entitled to her prescribed share, so she's entitled to, say, 1/8 of the estate. She then says to the husband, well, look, I've got enough property of my own. I'm not really concerned about who you leave your estate to or the share I'm entitled to. That actually gives you the permission to deal with that prescribed 1/8 part of the share, and you can actually add it to the 1/3 and leave it to whoever you want to. You agree, Maulana? Yes. Yes. That's called a waiver, isn't it? And as far as I know, it can be a verbal waiver as well. It doesn't have to be in writing. So a conversation takes place between a husband and wife. Well, to be honest with you, this is what's happened to myself. I've got a son and I've got a daughter. And when I was talking to my son Ali Raza about the split that the Sharia talks about, I said to him, you get double the amount your sister gets. And he turned around to me and he said, Dad, that's not really fair. I would want my sister to share half whatever I get. And to me, that's good enough, because he has agreed to waive the Sharia part of his share. Yeah. Well, I think you are following the Sharia. It's just that you don't need to get the waiver written down, because you would then write your will according to what my son said to me. So I put down that if my wife dies, then my kids will get 50-50 share. Yes, because it's translated in a will. Yes. 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 I understand. I haven't got a reference to it, but I understand it's Ayatollah Sistani's ruling as well. Yes. 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 It is possible after death to come to an agreement, and you can, if you've got an executor who says, look, I want to divide up the estate according to the Sharia, and all the beneficiaries are in agreement, but the will doesn't say that, then you can make what's called a deed of variation, which is actually recognized by the Inland Revenue, and you can do it 2 years, up to 2 years after death has occurred. So the distribution of the estate can be varied by agreement between the beneficiaries. Sure. You don't. You can leave whatever you want to whoever you want to, in whatever proportions. So you can say, I donate all my estate to the Battersea Dogs Home, for example. And as long as the will is valid, Battersea Home are going to challenge that up to the hilt if the family don't agree. Just the last slide then. Possible to make a Sharia will? Yes and no. English law will override if any conflict between the two. You've got to remember that. Where possible, you can leave in the prescribed portions, but care needs to be exercised. Thank you very much. And well, the conflict may be that you have you have done a will, left a Sharia will, which is not compliant with English law. And so if somebody then challenges it, it'll have to go through the intestacy rules. So there's a conflict there. So if you're making a will, make sure you make a will which is compliant with English law. Therefore, English law will then be the ruling on any dispute that arises. You do, yes. 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 Yeah. Yes, you can actually put those prescribed amounts, you can break it down, but it can lead to difficulty. Say if you own a house and your wife is living there and you die, then it will mean that the property will have to be sold and your wife will become homeless afterwards. Is that your intention? I mean, I don't know how Sharia deals with that. Yes. Yeah, yes, absolutely right. The executors or trustees have the ability to delay distribution for up to 12 months at minimum, yes. There is no maximum period. It depends. I mean, if the executors are delaying it for a long time, the beneficiaries might go to court and force the executors to actually administer the estate. No, you can't. Anybody who's over the age of 18 sound mind, you can appoint them as executor. Yes, you can appoint anybody who's over the age of 18. But if you're a Muslim, I understand that you have to appoint a Muslim mu'min person to be an executor in your will. Yes. Yes. If you can include assets which are held abroad in your will, because you're residing here. If you're a resident of UK and you make a will, then you can include assets which may be abroad, and it's up to the executors to then collect those assets and distribute them according to the wishes of the will. So if you make an English will and you go abroad and live in another country, I don't know what the position is, if obviously the legal system is different over there. You can, yes. Yes. You can, well, no, I mean, the basic position is that you would make a will which would distribute all your assets wherever they are in the world. It shouldn't matter whether they're in England or not. The executors should be able to get the legal documentation to then go abroad and deal with those assets as well, whether it means transferring to somebody else or whether it means selling the asset and distributing the money to the beneficiaries. Asad. Yes. No. If there are survivors, then they can come forward and they can register the interest with the Treasury Office, and they then have I don't know what the time period is, but there is a certain time period within which they've got to establish that they are related to the deceased. And as long as they fall within the categories of people specified in the intestacy rules, then they will be able to inherit, even though they might be living abroad, as long as they are able to show that they were the relative of the deceased. Yes. It doesn't matter. They were alive at the time they witnessed the deceased signing the will, and that's all that matters. Yes, they don't have to be alive at the time of the death of the deceased, as long as they were alive and they witnessed the will in the presence of the person who's making a will is called a testator. So if the two witnesses had witnessed the testator signing the will when he signed it, that would be a valid will. Somebody could come along and challenge it later on, but challenges are something different. Sorry, say again. Oh, the executor have to be alive. If you appoint one or two and they die, then the difficulty is that there won't be executors who will be administering your estate. What you would then have to do is you would have to appoint whoever is going to be under the intestacy rules, and they will have to then distribute, yes. Yes, yes. Yes, yes. Because you've got one executor remaining. No. If when you're making your will, it is better to appoint 2 executors and 2 substitute executors. So just in case either they pass away or they're not able or not willing to act, then in those circumstances you can have the 2 executors or 1 executor who's remained in the will as appointed as a substitute. They can then administer the estate. Yes, 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 yeah, absolutely, yes. Okay, any more? Thank you very much indeed.